morning, and thank you, Mr. Chairman. I also want to echo Mr. Boucher's comment that we look forward to working together in a bipartisan fashion on a very important bill. And I want to thank the witnesses for coming this morning. I think, for the most part, you're going to educate us. You're the experts here, and we respect your opinions. We want to do no harm here. So I think when you look at this possibility of federal legislation dealing with privacy, we want to make sure that it's consumer-centric. Consumers don't care if you're a search engine or a broadband provider. I just want to ensure that the privacy, their assurance that their privacy is protected. We must empower them to make these privacy decisions themselves. They feel, they know how much want to be collected and what should not be collected. Congress cannot and should not make that decision for them, but it can play a role in making sure consumers have the information simply to make their own choices. That means companies should be as transparent as possible about what information they collect and, of course, how they're using it. That way consumers will be better able to make informed privacy decisions. This transparency should include robust disclosure and notice outside the privacy policy. Notice and disclosure needs to be clear and conspicuous so the consumers know that. First, some information is being collected. Second, what is the information that's being collected? How is it being used? And third, how to prevent this information being collected if they so desire. By giving the consumer more robust and transparent information, we can strike the proper balance between privacy protection and strong Internet commerce. Furthermore, my colleagues, I want to emphasize two principles that should play a prominent role in our examination of this issue. First, we should apply the same privacy standard to companies that are engaged in similar conduct with similar information. But we should avoid applying those same standards to entities that do not use the same types of information for the same purposes and do not have anywhere near the same volume of information about the prospective consumer. For example, search engines and Internet advertising networks may use a consumer's visit to a particular website to create profiles for purposes not directly related to the reason for the visit. Other entities, like web publishers, collect information only to provide the very service the consumer has come for. Our approach should recognize that. Second, any legislation in this area should hold various parties accountable only for that which they know and control. We should be wary of efforts to make any one party responsible for the actions of others. Consumers' online activities provide advertisers with valuable information upon which to market their products and their services. Collecting this type of information for targeted advertising is very important because it simply allows many of these products and services to remain free to consumers. Without this information, websites would either have to cut back on their free information and services or would have to start charging a fee. Neither result is good for the consumers. Overreaching privacy regulation could have a significant negative economic impact at a time when many businesses in our economy are struggling. So let's be very careful on these issues before we leap to legislative regulatory proposals. When I was chairman of the Commerce, Consumer Protection and Trade, I held a number of hearings on privacies. I worked with Chairman Boucher, and we developed a Consumer Privacy Protection Act, which we dropped as a bill. This bill would have required data collectors to provide consumers with information on the entity collecting the information and the purposes for which the information was being collected. I believe it was and still is a good base bill to use as we move forward to develop a new privacy bill. Also, I'd like to bring up an issue perhaps that many of us have thought about, and I don't want to bog down our discussion about it. Which agency will regulate and enforce privacy standards? Will it be the FCC or the Federal Trade Commission? A combination or possibly a new agency? I know this issue won't be solved this morning, but it's something we're going to have to work out and work through, and I look forward to doing this on a bipartisan fashion. And I'd be interested, if possible, if some of the witnesses could give us their feelings about how the jurisdiction of this privacy bill would be best supervised with. So, Mr. Chairman, I would conclude by pointing out we've talked a little bit in previous hearings about deep pocket inspection. The point is that whether a company uses deep pocket inspection or reads your email directly, this should be part of the privacy rules in some way. So I think our witnesses can also help us on that particular aspect. So I look forward to hearing, and thank you for the opportunity to speak.